Welcome to the Supreme Court Podcast. All opinions expressed in this podcast do not reflect the views of the Supreme Court. For clarity, the text of the decision prevails.
What happens when the winning candidate's certificate of candidacy is cancelled due to false material representation? Who should take over? In the May 2022 national and local elections, Datu Pax Ali S Mangudadatu, then the incumbent mayor of the municipality of Datu Abdallah Sangki, Maguindanao, ran and won in the Sultan Kudarat gubernatorial race. However, even prior to the elections, two petitions had been filed challenging his COC. Both questioned the truthfulness of his claims that he was a resident of Purok Garden Tamnag, Lutayan, Sultan Kudarat, and that he had lived there for 1 year and 8 months before the May 9, 2022 elections. The petition said Pax Ali had continued to serve as mayor of Datu Abdallah Sangki, Maguindanao, and therefore had not abandoned his residence in the province of Maguindanao. On January 18, 2022, the COMELEC First Division issued a resolution cancelling the COC of Pax Ali for his failure to comply with the residency requirement. Noting that when Pax Ali filed his candidacy, he was the incumbent mayor of Datu Abdallah Sangki in Maguindanao, the COMELEC First Division held that Pax Ali violated Section 78 of the Omnibus Election Code when he committed a false representation in his COC on a material fact, which is a ground for the cancellation of his COC. This ruling was affirmed by the Court En Banc, prompting him to bring the case to the Supreme Court. In its decision promulgated on April 22, 2025, the Supreme Court En Banc resolved two issues. First, does the incumbency and continuous discharge of duties of public officials in one locality preclude them from validly acquiring a new domicile in another locality so as to satisfy the residency requirement under the local government code? More importantly, the Supreme Court revisited the second placer rule to determine who should serve the remaining term of Pax Ali, whose disqualification was upheld by the Supreme Court. Hi, I'm Attorney Mike Navallo, Supreme Court Chief Communications Officer. It's the 4th of July 2025, and today we talk about several very important issues in any election. The concept of domicile, false material representation, and the certificate of candidacy is a ground for cancellation of the COC, and the second placer rule, which up until the ruling that we will be discussing today, had allowed the second placer to take over in case the winner's COC is cancelled. We discussed these issues within the context of Datu Pax Ali S Mangudadatu versus the Commission on Elections et al., GR numbers 260219 and 260231, penned by Supreme Court Associate Justice Samuel H. Gaerlan, and decided by the Court En Banc on April 22, 2025. Joining us to talk about this case is Philippine Judicial Academy lecturer and former COMELEC Commissioner, Attorney Luie Tito F. Guia. Commissioner Luie, welcome back to the Supreme Court Podcast.
It's a pleasure and honor to be here, Attorney Mike.
All right, Luie, this is a very interesting case. The voting of the Supreme Court is very close. 7-6 to declare that there was false material representation, while 8-5 to abandon the second placer rule. We will discuss this later on, but just to start the discussion, talk to us about the false material representation rule as a ground to deny due course or cancel the certificate of candidacy of a candidate under Section 78 of the Omnibus Election Code. When is there false material representation, and which entries in the certificate of candidacy are considered material?
Okay, first and foremost, one cannot be voted on unless he or she files his certificate of candidacy. So what should be reflected therein? Well, in the certificate of candidacy, the requirements for eligibility of the candidate to the position he is seeking election to should be there. And Section 78 of the Omnibus Election Code says that the representation as to the eligibility of the candidate should be truthful. So if it's false, then that will give rise to what is called a false representation of a material fact. The material facts are those that relates to the eligibility of the candidate. For example, residence, age, citizenship, and the fact of being a registered voter in the constituency where the candidate is seeking to be elected. All right, and there are also other grounds
Mhm.
that may be raised as basis for saying that a candidate may have committed false representation of a material fact. For instance, if one is a dual citizen,
Right.
and under the local government code, a dual citizen cannot be a candidate, and therefore he cannot also be eligible to the effectively eligible to the position he's seeking to be elected to. Then and if he says he is not a dual citizen, then that is a false representation of a material fact as well.
And if I recall correctly, Commissioner Louis, you can even commit two offenses. First, by being ineligible, and second, by checking that tiny box in the certificate of candidacy, which says I am eligible, despite the fact that you are not. Right?
There is a question there other than the information that
Mm.
needs to be put in the certificate, which asks the person accomplishing the certificate if he is eligible to the office he's seeking to be elected to. And if he says yes, of course he will say yes. And it turns out to be false, then that would already be a ground to cancel the certificate of candidacy because of a false material representation.
And of particular interest to our discussion today, Commissioner Louis, is the concept of residence. And I understand that in election cases, we usually interchange the use of domicile with the concept of residence. Can you explain to us briefly what domicile entails?
Well, domicile means not only the bodily presence of a person in a certain locality, there should be an intent of that person to stay there permanently or maybe until he dies. Okay, so that should be the intention. And then if someone changes domicile, then he would have to have a bodily presence in the new domicile. He must also intend to stay in the new domicile permanently, and he must also evince or show his intent to abandon the previous domicile.
So in short, there are three elements
Yes.
to the concept of domicile. Now, in the case of Pax Ali, the allegation was that he misrepresented his place of residence. He claimed that he was living in Sultan Kudarat, but he continued to serve as mayor in a town in Maguindanao. That's at least until November 2021. Why was the place of residence material in this particular place?
Well, under the local government code, to be eligible to serve as a local government official in a constituency, and let's say in this case in a province, one has to be a resident of the province. Well, being mayor of Datu Abdullah Sangki, which is in Maguindanao, is not in Sultan Kudarat. So he cannot be considered to be a resident of Sultan Kudarat, because to be a mayor in Datu Abdullah Sangki, Maguindanao, you should be a domicile. Your domicile should be in that municipality.
In Maguindanao, which is a different province.
And in fact, he transferred his domicile from his domicile of origin in Sultan Kudarat to Datu Abdullah Sangki in Maguindanao.
Just to be able to run.
Just to be able to become a mayor.
To become a mayor. Now, in this case, Datu Pax Ali was saying he had been incrementally moving his domicile to his new residence in Sultan Kudarat. He presented proof as to his physical presence. Walk us through the argument that he cited. I believe he also cited some cases. For instance, Torino, Mitra, and Sabili versus COMELEC, to claim that his incumbency as mayor of Datu Abdallah Sangki did not preclude him from acquiring domicile in Sultan Kudarat.
Well, what he is precisely saying is that, the issue in this case is his residence in Sultan Kudarat, because that is the position that he was aspiring for at the time when the case was initiated. The fact of his being a mayor, said, should not affect his transfer of domicile from Maguindanao to Sultan Kudarat. And he cited the case of Torino versus COMELEC. Torino is actually a case involving then Governor Imano. He cited the case of of Torino versus
Mhm.
COMELEC involving the governor of Misamis Oriental who decided to run for mayor in Cagayan de Oro City.
Mhm.
Well, Cagayan de Oro City is a highly urbanized city
Mhm.
whose voters do not vote for governor
Mhm.
of Misamis Oriental. Now, he was allowed to
Mhm.
run for mayor in
Mhm.
Cagayan de Oro City because he was actually a resident of Cagayan de Oro,
Mhm.
even when he was a um, a governor
Governor.
of Misamis
Misamis Oriental.
Oriental. In the case of
Mitra in
Mitra,
Palawan.
okay, this has something to do with Mitra, who was then the incumbent uh, member of the House of Representatives representing the district of where Puerto Princesa and Aborlan used to belong. No, he was a resident of Puerto Princesa. Now he transferred his residence to Aborlan,
Mhm.
Palawan, and because he needed to do that. Well, that was his thinking because Puerto Princesa was just converted into a highly urbanized city again.
Mhm. Mhm.
Now, and whose voters cannot vote for governor. He was already intending to run for
Governor.
governor at that time, and he was also allowed
Mhm.
to run for
Mhm.
governor and recognize his transfer to Aborlan
Mhm.
from Puerto Princesa as a valid transfer of domicile.
So
Well,
that was his argument
that
that
was his
if in these
argument.
cases of Torino and Mitra
Yes,
the transfer was allowed, so should his transfer be recognized
that is his
by
argument.
COMELEC. And several justices agreed with Pax Ali. You have Justices
Mhm.
Ramon Paul Hernando and Ami Lazaro Javier, for
Mhm.
instance, comparing his case to that of Mitra. But the majority of the court did not seem to buy that argument. They said that he was mistaken in relying on these cases. How did the majority explain that? What's the difference between the Mitra and Torino cases from the case of Datu
Well,
Pax Ali?
the majority thought that the circumstances in the case of Torino and Mitra are different
Mhm.
because geographically, for instance, in the case of Torino, Cagayan de Oro is in Misamis Oriental,
Right.
so he need not change his
Domicile
domicile
or
anyway.
residence.
Yeah, his domicile anyway, and in the case of Mitra, it's the same thing.
Mhm.
I mean, he would be if he would be representing the same district actually.
Mhm.
So there is really no practical reason to distinguish their domicile. So that should not have matter. Or that should not matter.
Mhm. Mhm. And unlike in the case of Dato Pax Ali.
Here you have two provinces. So
Mm.
remember, he was running for governor of Sultan Kudarat, but his previous residence was or his domicile was Maguindanao.
Mhm.
So
Mhm.
magkaiba yung probinsya.
Mhm. Mhm. And did it matter, Kumliwi, that Pax Ali was raised in his ancestral house in Sultan Kudarat, the family's ancestral house? Because Justice Josep Lopez said in his dissenting opinion, domicile, once lost, can easily be regained. And according to Justice Lopez, he showed some manifestations that he was really intending to go back to the original domicile, which is in Sultan Kudarat. How did the majority address this point?
Well, first and foremost, the majority conceded
Mhm.
that he has bodily presence and
Right.
residence he has his residence in Sultan Kudarat. Okay, that's clear. But the question is, did Mangudadatu have his
Then
intent to stay in Sultan
Sultan Kudarat.
Kudarat permanently and abandon his previous domicile in
Mhm.
so one thing more is that the the majority cited the fact that in his pleadings,
Mhm.
Mangudadatu even admitted that he indeed transferred his domicile,
Mhm.
and that's why his word was to reestablish his
Mm.
domicile in
Sultan
Sultan
Kudarat.
Kudarat. So if you say you reestablish, then it means there's an admission that you lost
That
your
domicile.
that domicile, and then you want to reestablish it.
Mm.
And the fact that he was a mayor of Dato Abdul Sangki and did not uh, resign
Mhm.
supposedly at the time that he
Filed.
supposedly have showed his intent to go back to
Sultan Kudarat.
Maguindanao, to
To
Sultan
Kudarat.
Kudarat, yes, did not show any intent of him uh, staying in Sultan Kudarat and abandoning his previous domicile in Maguindanao.
Although the decision did acknowledge that he resigned as mayor of Datu Abdallah Maguindanao, but only in November of 2021. And the court said this was a mere afterthought because you already have two petitions filed against you after you filed your certificate of candidacy. So why did the court say that this is proof of misrepresentation, that this was deliberate?
Because when he filed his certificate of candidacy, he was still, performing the function of mayor. Remember, when he resigned, it was after he filed his certificate of candidacy. And in fact, it was after a petition or two petitions were filed against him. So he knew all along that he was not a domicile of Sultan Kudarat.
Kudarat,
And
right.
that's why he needed to resign to show and to perfect his claim that he had already transferred his domicile to Sultan Kudarat from Maguindanao.
Assuming that we base it from November 2021, would the period between November 2021 and May 2022 have been enough for him to establish
It wouldn't be
domicile?
enough because that would be less than 1 year from the day of the election. That will be barely 5 months.
Yes.
So he would not be qualified, or he would not be eligible on the issue on the matter of residence.
And this brings us back, Luie, to the main question that was answered in the decision. Does an elected official's incumbency and continuous discharge of his or her duties in a different locality preclude him or her from validly acquiring a new domicile choice in another locality for the purpose of the local government code's residency requirement? You have Justice Ben Kagiwa saying, in his opinion, that you can actually change, but you risk your residency being questioned. And since residency is a continuing requirement, you actually risk losing that particular incumbent post. But what did the majority say about this? How did the Supreme Court, at least the majority in this case, decide this issue?
Well, the majority said it's not. In effect, it said that it's not basically, it's not really conceptually, it's not the fact of incumbency, but the lack of intent manifested by his remaining to be a mayor, or his continued performance of the function of a mayor in a locality different, located in a province different from that he was running for. So that's how the Supreme Court majority decision saw the circumstances.
So in effect, is the Supreme Court saying that when you are an incumbent, you cannot claim that you're establishing another domicile in another province, especially if they are geographically apart. They're not within the same geographic area, unlike in the case of Torino and Mitra, where the new supposed domicile is within the same province. So the solution for that would be, if you're a current mayor of one municipality in a province and you want to run in another province, you should resign.
Well, that is the implication of the majority decision, and because and what was continually emphasized in this decision is that the eligibility of let's say a local of an elected public official should continue not only at the time that when he was elected, but during the entirety of the term of office.
Right. And with the disqualification of Pax Ali, Commissioner Luie, and the cancellation of his certificate of candidacy, the next question would be, who would fill up the vacancy and serve the remainder of his term? Before we go into that, can you give us a discussion first on the prevailing rule when it comes to cases where the COC is cancelled or denied due course? Up until this case, what was the prevailing rule?
Well, the prevailing rule, which actually started in the case of Halos Hos versus COMELEC, which was promulgated in 2012, said that if the ground for the a material misrepresentation, then that would mean that the certificate of candidacy is void ab initio. So it never had any effect. So the candidate who accomplished a certificate of candidacy that is void ab initio is never a candidate. Or if he's not a candidate, according to the Omnibus Election Code, the rules on appreciation, a vote for a non-candidate will be considered stray. Okay. So walang boto. There's no.
It's not counted.
It's not counted. So if that candidate turns out to obtain the highest number of vote in situation where COMELEC was not able to resolve the case with finality before election, then it is as if that the vote that candidate obtained becomes,
uncounted or stray.
not counted. I mean, so he's no longer the first placer. The second placer becomes the first placer.
So that's the second placer rule.
That's the second placer
So
rule.
meaning
That's
the candidate, the qualified candidate with the highest votes.
the qualified candidate with the highest vote rule, and that is what one of the separate opinions
And this
described.
started just in Halos Hos in 2012, at least according to the
Well, there were two
financial.
cases that adopted that rule sometime in the 80s, but consistently it has been the rule on succession that has prevailed until
Halos
2012.
Hos. So before 2012, it was the rule on succession.
Yes.
Right.
Well,
Talk to us a bit more about the rule on succession.
well,
under the
rules
local
on
law.
succession can only come about at the start of the term of office, of course, because there will be no vacant. Succession can only set in when there's vacancy.
Right.
Okay, there can only be vacancy when at the time when the term starts and there's no one to occupy the office.
Right.
Okay, in this case, when the one who obtained the highest number of vote is not qualified, then there is a failure to qualify.
Right.
Okay, if there's a failure to qualify, I think the local government code, as pointed out in the majority decision, is clear. It should be the elected vice mayor or vice governor, whoever the local government designate as a successor to the one who was disqualified, would now become occupy the position.
So now that's the rule on succession, right? So in this case, Commissioner Luie, 8 members of the court, including Chief Justice Alexander Gesmundo, Associate Justices Alfredo Benjamin Caguiwa, Rodil Zalameda, Samuel Gaerlan, who's the ponente here, Ricardo Rosario, Osemaides Marquez, Antonio Co Jr., and Maria Filomena Singh, they all voted to apply the rules on succession under Section 44 of the Local Government Code. And the majority abandoned the second place rule for lack of legal basis and for being inconsistent with the essence of republicanism. Why did the Supreme Court say there's a need to revisit the second placer rule? Can you expound on the reasoning for abandoning a rule which has been in place for over a decade?
Well, the Supreme Court cited the fact, and which was the previous argument or reason that prior to 2012 was the reason, reasoning of the Supreme Court coming up with decision in similar cases, is that once a person is not elected, meaning he is not the one who obtained the majority of the votes cast, then he's not elected. And someone who's not elected was rejected by the people. You cannot have someone occupy a public office if he has been rejected by the people. So that's the principal logic of the majority decision. So a second placer is a loser. He can never be a winner. So that's the implication of the decision of the majority here. And if that is so, then no one is elected. So there is a failure to qualify on the part of the person who obtained the highest number of votes. If there's a failure to qualify, then the local government code sets in, who would then become the governor in this case.
This doctrine of rejection of the second placer, according to at least Justice Ben Caguiwa, is supported by law and public policy. What was their basis for saying this is supported by law and public policy?
Well, first and foremost, It's a principle of republicanism,
Mhm.
the principle of democracy. According to the Supreme Court, they say that, as I've said, a candidate who's been rejected
Mhm.
conceptually cannot rule
Mhm.
because he was rejected.
Now, and there have been, as you mentioned earlier, inconsistent applications of this rule up until 2012. And now you have five members of the court: Senior Associate Justice Marvic Leonin, Associate Justices Ramon Paul Hernando, Ami Lazaro Javier, Mario Lopez, and Josep Lopez. They voted against
Mhm.
abandoning the second placer rule. Now, for the purpose of discussion only, just so that we can understand why they oppose that, what points did they raise against abandoning the second placer rule?
Well, the fact that a certificate of candidacy of a candidate who made false representation, who is not qualified under Section 40 of the Omnibus Election Code, or Section 40 of the Local Government Code and Section 12 of the Omnibus Election Code, means that if the ground for disqualification existed at the time of the filing of the certificate
Mhm.
of candidacy, then the certificate candidacy is void. If certificate candidacy is void, then there is no candidate in the first place. So you cannot vote for a non-candidate.
Mhm.
So
Mhm.
the votes they may have obtained are considered, invalid votes. You
Mhm.
cannot count them. So technically, the first placer is the one who came next.
Mhm. The
So
qualified
that
one.
is also, according to them, that is consistent with republicanism. You have the one who obtained the highest uh, valid votes cast in an
Mhm.
election.
And Justice Josep Lopez also pointed out that if you were to allow the next in line under the rule of succession to take the post that was vacant, you would actually ignore the fact that the people voted for that person for a different position, not for the position which was vacant.
Yes.
That's the point of Justice Josep Lopez. But ultimately, what is the rule that the Supreme Court decided on in this majority decision? And how does it apply now? I mean, how do we, if this decision were to be affirmed in a proper motion for reconsideration, for example, what is the rule now that the Supreme Court decided on, at least with respect to this case?
Well, it would mean, therefore, that the so-called second placer would no longer have a chance to be occupying the contested office,
Mm.
because he did not win the elections, and someone who did not win the election cannot cannot occupy
Mhm.
cannot be a public servant, cannot occupy an elective public office. So that rule would have to be followed out if this case becomes final.
So there's no more distinction as to the cause of the disqualification or cancellation of the COC. Um, as long as the seat is vacant, the rule of succession applies,
Yes,
regardless of the proceeding, regardless of the situation.
that seems to be the implication of the Supreme Court
Mm-hmm.
decision.
Mm-hmm. And of course, this is not yet final because it can
Yes.
still be subject to motion for reconsideration. So when will this be implemented?
Well, after the motion for reconsideration, there's one filed,
Mm-hmm.
is decided, and then then that would, of course, make the decision final
Mm-hmm.
and executory, and that would therefore define
Mm-hmm.
the rules
Mm-hmm.
that would in situation that can happen henceforth.
And would you consider this a landmark ruling, Com Louis? I mean, you serve in the COMELEC for the full term, so you've probably gone through similar cases like this one. How significant a change in terms of the doctrine is this
Well,
ruling?
operationally, what COMELEC will do is it will no longer proclaim the second placer. Then
Mm-hmm.
it would just have to, leave it at that until the time that the term of office starts.
Mm-hmm.
And then if there's no one, occupying the office, and obviously there will be no one if the one obtained the highest number of vote is disqualified, or
Mm-hmm.
is declared, or is if there's a material misrepresentation, then the rule on succession would come, and that would already be something that DILG should be monitoring instead of COMELEC.
All right. Very, very interesting. And I learned a lot from this discussion today, Commissioner Louis. And a final word from you, perhaps. What's the key takeaway from this case of Datu Pax Ali Mangudadatu, that perhaps not only those who intend to run or politicians should keep in mind, but voters as well?
First, I would like to look at the burden that is imposed on COMELEC to really make their decision or its decision way before the election. That would have resolve all issues regarding this. So it's when a case, a disqualification case, or a material representation case is decided way before, then it's clear that the one who was disqualified or whose certificate of candidacy was cancelled would not anymore become a candidate. So that would have cleared the matter. So I think that's the most important thing. And for voters, be discerning probably. I mean, know the qualification or the eligibility of the candidates you're voting for, so that you will not waste your votes, so to speak.
All right. On that note, thank you so much, Commissioner Luie, for joining us today.
Thank you. My pleasure.
To our listeners, if you wish to read the full text of the decision of the Supreme Court, please visit the Supreme Court website, sc.judiciary.gov.ph, and search for GR numbers 260219 and 260231, Datu Pax Ali S Mangudadatu versus the Commission on Elections et al. Here's Tefa Tenido Beltran, Supreme Court Information Officer, for recent updates about the court.
From the Supreme Court of the Philippines, here's the latest. The Supreme Court En Banc, during its session on July 1, 2025, issued a writ of kalikasan in a case which seeks to stop the construction of the Samal Island Davao City Connector Bridge project. The writ was issued against the Department of Public Works and Highways, Department of Environment and Natural Resources, Samal Island Protected Landscape and Seascape Protected Area Management Board, and China Road and Bridge Corporation. Petitioners Carmela Marie Santos, Mark Peñalver, and Sustainable Davao Movement claim that the project will cause actual, serious, and irreversible damage to coral reefs in Paradise Reef, Samal Island, and Hizon Marine Protected Area in Davao City. The court required the respondents to file a verified return on the petition within 10 days. It also referred the prayer for the issuance of a temporary environmental protection order to the Court of Appeals Cagayan de Oro Station for action. The Supreme Court has ruled that a child's rape by her adoptive uncle does not warrant a harsher penalty because they are not related, based on the prevailing law at the time the crime was committed. In a decision written by Associate Justice Japar de Maampao, the SC's Third Division found a man guilty of raping his 10-year-old adoptive niece, but ruled that his penalty cannot be increased by the qualifying circumstance of relationship. The SC upheld the accused's conviction, but declared him guilty of statutory rape instead. The SC clarified that at the time the rape was committed, the existing laws on adoption did not consider the victim to be related to her adoptive parent's family. While RA number 11642, or the Domestic Administrative Adoption and Alternative Child Care Act, expanded the relationship to include the adopter's parents, legitimate siblings, and legitimate descendants, it took effect only in 2022 and could not be applied to this case since the crime was committed in 2012. In another case, the SC has found two managers of a pizza restaurant guilty of simple theft for having kept service charges that should have been paid to the restaurant's employees. The SC Second Division, through the penensya of Associate Justice Antonio Co. Jr., sentenced two store managers at a Shakey's branch in Angono, Rizal to 6 months in prison. It also ordered them to pay their fellow employees the withheld service charges. The SC, however, modified the conviction from qualified theft to simple theft. Under the revised penal code, theft becomes a more serious crime known as qualified theft when it involves the abuse of trust or confidence. In this case, while the store managers took the service charges meant for the employees, the SC clarified that the victims were the employees, not the employer, Big G Phil Foods and Entertainment Inc. Since there is no special trust relationship between managers and rank-and-file workers, there was no abuse of trust or confidence in this case that would have qualified the theft. In another decision, the SC has ruled that an acknowledgement receipt cannot be considered a contract of sale unless it clearly shows that the seller intends to transfer ownership of the property to the buyer. In a ponentia by Associate Justice Maria Filomena Singh, the SC's Third Division ruled that the agreement between Virgilio Chavez and his fellow petitioners on one hand, the spouses Joselito and Adriana Gopez on the other, was a contract to sell, not a contract of sale. The SC explained that in a contract to sell, the seller does not agree to transfer ownership of the property just yet. The seller only commits to fulfilling their promise to sell the properties and transfer title to the buyer after an event, typically the full payment of the purchase price. In this case, the acknowledgement receipt did not include any promise to transfer ownership. It only showed that the spouses needed to meet certain conditions: the payment of the purchase price and preparation of the contract to sell, deed of sale, and estate settlement. On Monday, the SC, in partnership with the Korea International Cooperation Agency, or KOICA, held a kick-off ceremony for the implementation survey of the project titled Improving Judicial Efficiency and Accessibility by Innovating Philippine Courts at the Supreme Court in Manila. Chief Justice Alexander Esmundo, Senior Associate Justice Marvic MBF Leonen, and Associate Justice Raul Villanueva led the ceremony, while Country Director Mr. Jung Yong Sun led the team from the KOICA. In line with the Strategic Plan for Judicial Innovations 2022 to 2027, the project aims to modernize Philippine court systems, to facilitate the speedy delivery of court services by leveraging the use of modern technology, and to enhance the transparency, security, and efficiency of court processes in the Philippine judicial system. Target outputs of the project include an electronic verification system and a case record management system, capacity training of personnel for digital transformation, and digitization of court records. In a special session on Tuesday, Integrated Bar of the Philippines officers and Board of Governors took their oath before the Supreme Court En Banc at the Session Hall in Manila. Associate Justice Ramon Paul Hernando administered the oath of office to IBP National President Attorney Alan Panolong. Associate Justice Henry John Paul Inting swore in IBP Executive Vice President Attorney Randall Tabayoyong, while Associate Justice Josep Lopez led the oath-taking of the 27th Board of Governors. Meanwhile, on July 2, 2025, the Office of the Court Administrator, or OCA, held a turnover ceremony of the guide to the OCA circulars issued from 2022 to 2024 at the Supreme Court in Manila. Former Court Administrator and current SC Associate Justice Raul Villanueva and OCA Officer-in-Charge Assistant Court Administrator Lilian Baribalco led the event and turned over copies to the judges present. OCA circulars are also uploaded on the OCA website, oca.judiciary.gov.ph. Finally, on Wednesday, Associate Justice Raul Villanueva and Court of Appeals Associate Justice Jose Lorenzo de la Rosa held a ceremonial signing of the deed of donation to the court of a parcel of land in Poblacion, Pila, Laguna at the Supreme Court in Manila. The 1,550 square meter property donated by Justice de la Rosa will be used for the construction of the Pila Laguna Hall of Justice. Justice Villanueva, then the court administrator, served as the signatory on behalf of the court during a signing held earlier in March. Assistant Court Administrator Lilian Baribalco, officer in charge of the Office of the Court Administrator, was also present during the ceremonial signing. You are now up to date with the Philippine Supreme Court. I am Tiffany Beltran, Supreme Court Information Officer.
And that's our podcast this week. Join us again next time for a detailed discussion of select cases decided by the Supreme Court. I'm Attorney Mike Navallo, your Supreme Court Chief Communications Officer. You can catch this podcast on the Supreme Court Public Information Office's accounts on X, Facebook, Instagram, YouTube, and Spotify. You can also catch previous editions on our website and on Spotify. This podcast episode was produced by the Supreme Court Public Information Office with Attorney Karen Martinez, J. Rimpilio, and May Sibal as researchers, Brian Austria, Don Ryan Balza, Don Ensolano, Austin Eliscad, and Bea Batong as audio and video editors, and Tyke Flores and Jerome Batumalaki as web editors.